Hello, and thank you for joining us for another Whitehead Moncton podcast. Today we're going to be talking about family law, and more specifically, we are going to be unravelling some of the most common myths of the law surrounding marriage, divorce, financial remedy and children matters. I'm Judith Harling-Coward, a senior family solicitor working in the Canterbury office of Whitehead Moncton, and I'm here with one of our trainees.
Hello, I'm Lawrence Bowles. I'm, one of the trainee solicitors currently working in the family team. So if we get started into the podcast then, the sort of structure of it is that I've got a number of statements here, Judith, and I'm going to read them out to you. And Judith, you're going to shed some light on the truth behind those statements. And hopefully by the end of the podcast, we will have cleared up some of the most widespread myths and misconceptions that exist among the general public when it comes to family law.
Fantastic.
Okay, so if we start with the first statement then, once we're divorced, our financial connections will automatically end.
So this is a common misconception. Some claims as a spouse may end, such as claims for pensions and matrimonial home rights and inheritance rights. But unless the parties have remarried, then claims for other rights under the law and the Matrimonial Causes Act live on. And this includes claims for spousal maintenance, property and lump sum orders as some of the key orders that are considered and made upon financial separation. So it's really essential that if you're considering divorcing, that you attend to your financial separation and seek early advice on this at the time or as soon as possible, at the same time as you are considering your divorce, so that the terms of your financial agreement or your financial separation are bound up in a legal document called a financial order, final order or a consent order and lodged with the court. So your legal ties will actually end in conjunction with the terms of the order once approved by the court. And the court would need to approve what is called a clean break order for all financial ties to actually end.
Okay, thank you, Judith. That's very interesting. So one thing that I did pick up on that you were saying there was about consent orders. So what would you say the difference is between sort of a financial remedy order and a consent order?
Okay, so a consent order is a document, a legal document, which contains the terms of agreement reached by the parties, and that contain a number of provisions that deals with kind of each and every asset or how the income is going to be dealt with and treated, and it is a consent order because it's been reached by consent, whereas a final order would be an order made by the court if the spouses were unable to reach agreement and needed to involve the court, needed the assistance of the court. A final order in a financial remedy matter would be at the end of the process, so the final hearing. Right. And that is when the judge makes the decision for the parties on how the assets should be split or divided and what should happen. But most often, thankfully, because of it's very costly heading to court, and it can be quite stressful for divorcing spouses. We are able to help parties reach agreement, and therefore once we've reached agreement, we draft those terms that have been agreed into a consent order, and that's filed with the court. So I hope that helps.
Yes, it does. Yeah, thank you. And you also said as well about the court would need to approve a clean break order. And when you talk about clean break orders, what are some of the most common provisions under that type of order that you might sort of expect to see?
So a clean break order is when each party will go their separate independent financial way. That means that all claims end against the other at that point when the court has approved the order, not when it's just been agreed. The court has to consider the terms and see whether it's fair in the circumstances, and it can raise questions. So things like spousal maintenance, child maintenance if the earner earns above a certain threshold of income, lump sums, property, decisions on what should happen to a property, whether it's transferred or sold, or if there's an adjustment on a property, measure orders, which is when one spouse will remain in the home, usually for a period of time. That would not be a clean break order because that is dealt with after the order has been approved by the court. But some of the provisions in the order can take place for months or weeks or many years afterwards. Clean break order means at the point when the court has approved it, there are no more ties.
Right, brilliant, thank you. So I suppose we should move on to the second statement then, which is we will inevitably have to go to court and battle it out. Judith, is this true or false?
False, Lawrence. With regards to divorce, it's very rare to attend court these days, particularly with the new law that was brought in April last year. So it's now very much an administrative application which the court can deal with online or on paper. There were a number of ways that you could divorce, and it often required one spouse citing unreasonable behaviour, or there might be a cross application for a petition for a divorce, and that could end up in court. But thankfully, the new law has been brought in, and you're very, very unlikely to go to court to deal with the divorce. With regards to financial separation, there are a number of approaches that you could take which do not involve the court as well. So you're not inevitably heading to court. This could be by way of agreement between spouses. It could be by mediation, which is a really cost-effective way, suitable when both parties are willing to try and reach agreement and are willing to compromise, and also spouses who can trust each other when disclosing their financial position. You could deal with this through solicitors, which is often the way spouses tend to do this, which would be either by reaching agreement which your solicitor can negotiate either with your spouse directly or with another solicitor representing the spouse, which the agreement is then bound up into a consent order, and we ask the court to approve that. Or you can first go through what is called a voluntary exchange of full and frank financial disclosure, which is dealt with through solicitors as well. And from that, then you can come to an agreement at that point, or if you can't come to an agreement, you can look at one of the other ways of trying to settle your finances. You can make use of collaborative lawyers who work through the issues for the spouses together with their clients. Roundtable meetings. There's a relatively new approach of working with one lawyer advising both parties. You can use arbitration with the assistance of an arbitrator rather than the judge at court. And usually you would have solicitor assistants and barristers for that arbitration. And that can be a lot quicker and less expensive in terms of the process. And court is usually the final option. And there's a good reason for this. I've touched on it earlier, but the costs and the delays and stress of proceeding through the family court, it really mean that you should, or divorcing spouses should give consideration to the other options that I've mentioned, and a good solicitor will discuss these options with you. And some of these options can be chosen along the way. Right. So you're not necessarily bound once you've chosen a particular way to stick with that. So even if you head to court, it means you can settle before a hearing, or you can settle along the way once a hearing has taken place. Okay. You can opt for mediation at some point if both parties agree to do that. You're not stuck with what you've opted for at the beginning, and it may be sensible to reconsider your position along the way.
Brilliant. Okay, thank you. So yeah, very useful information there, and quite clear that there are lots of other routes other than just going, straight to court.
Absolutely.
That should be explored, first. So if we move on to the third statement then, which is that assets are always shared equally on divorce, so a 50-50 equal split between spouses.
The starting point is an equal division of assets, but this can be departed from in consideration of needs, and in some cases where there is a surplus of money, which is not for most cases, but lifestyle can play a factor as well. So solicitors and the court would be considering the welfare of any minor child, the income and earning capacity and property of each spouse has or is likely to have in future, financial needs and obligations and responsibilities which each of the parties has or is likely to have in future, standard of living that has been enjoyed by the family during the marriage, the age of each marriage and the duration of the marriage, and any physical or mental disability of spouse. So health of the party can be taken into account, and for the the children as well. Any contributions that either has made or is likely to make for the future welfare of the family. And that includes looking after the home or the children of the family as well. Conduct can be taken into consideration, but only if it's so bad that it would be unfair for the court to disregard it. So that's not, it's not relevant for most cases.
Right.
Also, any value of any benefit that the spouse would lose by virtue of being divorced, such as some of the pension claims as well.
Okay. All right, brilliant, thank you. So one statement that I think will probably sound all too familiar for you as a solicitor, as I think you'll agree that it's one which many clients tend to sort of ask, one of the sort of common misconceptions, which is, if I leave the marital home, I give up my rights to it. What are your sort of thoughts in that regard?
So with regard to financial separation, the family home would still form part of the matrimonial assets that are considered by solicitors or the court. And that is the case even if the property is held in just one sole name of one of the parties. So the solicitor may advise you to remain in the family home whilst you're working through your position, working out your financial separation and what's happening with your divorce. But if it's untenable, then you need to speak to your solicitor to get early advice on this. It's also really important to consider the impact on the children, on any children of the family, when deciding to remain or to leave the family home. But you haven't given up your rights to it if you decide to leave, and it will all be considered as part of the matrimonial pot.
Right. Okay. And so I guess then off the back of that, another sort of common question which you might find is often asked is, if I were to leave the home, Judith, and my spouse were to change the locks, what would happen in that situation?
Well, it's your home still. If your name is on the register, it's your home, and you can re-enter that home. However, if there has been an occupation order or a non-molestation order, some kind of injunction that prohibits you from returning, then that may be a bar to you, kind of rocking up and re-entering, going back into the house. But you are entitled to re-enter. However, with a caveat to this, is that it's a very sensitive situation when locks are changed and when people are divorcing, and you should seek advice on how to approach this. And communication is really important and key to trying to ensure that circumstances such as this are kept as calm and calm as possible, and that any children of the family remain protected from any, I guess, difficulties between the parents.
Yeah. Brilliant, thank you. So a few more statements then to make. The next one I've got is where children are involved. So moving on to sort of focusing more on children now. The children will automatically live with the mother, and the father will only have contact on very specific occasions. Is that sort of true or false?
This is a very outdated misconception, again, but which we, as lawyers, we still hear often from divorcing parents. The children's best interests come first, and a child arrangements order will involve consideration of how the child's needs are best met, which might mean residing with either of the parents, and often under a shared care arrangement, if that's what is agreed, the child may live or spend time with both parents. It need not be equal; it's got to be in the best interests of the child, and it's really important for parents to make sure that they don't forget that it's a day here or there, or whether it shouldn't be about counting days essentially, or how many days the child is with each parent. It's got to be suitable for the child who may be being shipped around from home to home and feel quite unsettled. So if you can't reach a sensible agreement, which is not always the case, then if you do have to proceed and to the court, you would need to attend mediation unless exempt. But CAFCAS, an organisation appointed by the court in child proceedings, can give their guidance on where the child should live and what the arrangements should look like. If you were proceeding through the court, then each parent will have an opportunity to explain their reasons for why the child should live with them or what the arrangement should look like. And if the court is involved, then the court will have the final say. So it's a really good reminder that it is worthwhile trying to agree sensible arrangements where each parent can input and try to shape those arrangements themselves before considering heading straight to court.
Okay, thank you. That's really interesting. And I think, you're right. It's a case of sort of bearing in mind that it's not necessarily a tit for tat between, who has them 10 days and who has them 11 days out of a holiday, but more sort of
not.
focusing on.
And the child won't often notice about that. It's the parents thinking about it, and it's not the child may not know. There just needs to be, some sensible routines, some sensible arrangements in consideration of what's best for that specific child.
Great, thank you. So. Got a statement here then that says we have lived together for years and years as common law partners, so we have the same rights and protections as a married couple when separating. Thoughts?
Another false. There's little protection for unmarried partners, and they're not protected under the law that provides the rights and protections for married couples, where there is some good protection afforded to married parties. Unmarried cohabitants should seek early advice from a solicitor.
Okay.
I think it's all about having that knowledge to then make decisions on what steps you need to take. So it's important to have that advice to discuss what should happen to property and assets if the relationship were to fall apart. So really at the start of the relationship or the start of moving in, or if there's any kind of property that you need to consider, because a cohabitation agreement and or a declaration of trust may offer some protection in the absence of being married.
Brilliant. Okay, so what about prenups then? So traditionally we hear about prenups in the paper, in the news, and they're typically, for the rich and famous. What's the current sort of legal position when it comes to prenups in this country?
Yeah, so prenups here are still not binding in law as they are in some other countries, but the court here looks to uphold them if the process in making the prenup has been dealt with properly, and if making an order to uphold the prenup is fair in the circumstances. So the court retains the power to consider the financial position of the parties and make a different order based on needs or fairness and circumstances of the parties.
Right.
And I think that's quite unique about the courts here of England and Wales. They are interested in making sure that a potentially vulnerable party, financially vulnerable party, is protected. If one party has more financial wealth, or if a person is remarrying and has children from the first marriage, where they might want to protect some money for the children, it's particularly worth seeking advice on whether a prenuptial agreement could assist. They're certainly not just for the rich, and it may be a sensible step for people who are looking to get married to take or explore.
Okay, brilliant. Thank you very much then, Judith, on that. And this sort of brings us to the last statement that I have on my list here, which is, whilst I appreciate it's quite a broad statement, I think it sums up the podcast quite nicely. So divorce is always expensive. So is there any advantage to getting divorced?
So the divorce itself is now actually relatively inexpensive. I've mentioned the new law that came in April 2022, and that can simply be the cost of a court fee, which currently is at £593, if you're dealing with it yourself, which is possible to do because it is much more of an administrative process, and there's no longer the need to meet the threshold to be able for the court to be able to approve that you should be able to divorce. So that part's inexpensive.
Right.
It's really the financial element that can be expensive to deal with. Not always, but it can be because it can involve complex considerations or issues. And sometimes where there is one party who's being particularly unreasonable, which can increase costs. But it's certainly worth attending to your financial separation as soon as possible, at the same time as the divorce is being considered. I've touched on this, I think, earlier, but if it's left, then financial claims against the spouse can continue to remain live, even for many years after. So it's beneficial and better to try and reach an agreement so each spouse knows exactly where they are financially and can move on. in my experience as well, when there are children involved, settling the finances and the divorce often then helps parents to be able to focus on the children and co-parenting, which is really important for the children's well-being. So I would say very, as critical advice, that don't just deal with the divorce. You need to be looking at the finances in order to ensure there is a fair agreement and to protect yourself financially going forwards.
Brilliant. Thank you very much, Judith, for joining me today with this podcast. And thank you, of course, to our listeners for listening. If you would like some assistance in relation to any family matters, whether that be divorce and finances, children matters or otherwise, you can contact us via our website, which is whitehead-moncton.co.uk. If you contact our switchboard at 01622 698 000, you can ask to speak to a member of the family team there. Or alternatively, you can contact Judith and I directly. My email address is lawrencebowles@wmlaw.uk, and Judith, yours is?
Judith Harling-Coward at wmlaw.uk.
Brilliant. Thanks
Thank you
again
very
for listening.
much.